everybody, please silence your cell phones. Put them on silent, off, stun gun, whatever. All right. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 of the Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made. Which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Okay, may we stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Ms. Deborah, can you swear in the staff, please?
Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Jeez, we got a short staff today. Okay. Everybody had a chance to review the minutes from last month?
There's one thing I noticed on the bottom of page 5, it doesn't show the roll call for case number 9-05 CEB.
Does it show it on the next page?
No.
Yes, it does. Go at the top of the page. Next page, page 6. Doesn't show you're right. It doesn't show the roll call, but
Yeah, it does not show the roll call.
Can you put the roll call in there for that, Megan?
It shows who made the motion,
Okay.
who seconded, but it doesn't show that we all voted on it.
All right. Any other corrections or? Okay.
And that was unanimous.
Okay. All right, I need a motion with the corrections so noted.
Move to approve the minutes of the meeting of Monday, January 14th with the corrections noted.
Any questions? I have a second, please.
Second.
Okay. Who said? Ed?
Second.
All right. All, roll call vote, please.
Member Edwards?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes. Motion carried. All right. Chelsea, you're up, please, ma'am.
Thank you and good afternoon. The first case on your agenda is for case number 18-146 for the property located at 20 North Washington Avenue. I'm happy to report to you that the property is in compliance. You may have noticed it if you drove by the corner of Garden and Washington. I have Officer Lewis here to provide testimony if there's any questions of staff. And with that, I would turn it over to the board to find that this property is in compliance. There was a building permit issued and closed out for the demolition of the property.
Yeah, it's done. I'll
Yes.
Pass it. All done. Any questions of Chelsea or of anyone else? Can we have a motion, please?
So moved?
No, so moved.
Okay.
I make a motion. Just a motion to close that case number.
I move to find case number 18-146 in compliance.
Second.
All right, any questions? Motion by Ashley, second by Mr. Richardson. Any
Nice.
Roll call vote, please.
Member Herman?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Edwards?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes, motion carried. All right, so moved.
Thank you. The next case on your agenda, number 18-02, for the property located at 2767 Pine Ridge Drive. Again, I'm happy to report that the city has found this case in compliance, and Officer Tuggle is here to provide testimony if there are any questions of staff. Compliance was achieved by February 5th, 2019, as ordered by this board. Yes,
Was
sir.
this the case for off-street parking?
Yes, sir.
Okay.
Any questions? Any questions by Ashley or Chelsea or anyone?
Move that we find case 1902 in compliance.
Second. Any questions? Okay, roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Edwards?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes. Motion carried. Motion carried. Okay.
All right, the next case on the agenda is number 19-05 for the property located at 2314 South Hopkins Avenue. Officer Lewis was assigned to this case, and this property was brought before this board last month, and the owner was ordered to obtain a permit for the structure on the site that has not been found in compliance as of this date. So as I continue with this case, I'd like to introduce a PowerPoint presentation for non-compliance of this particular case, number 19-05.
And again, this is continuing to bring y'all a newer format of non-compliance to remind what happened is the case summary, the violations, and then after Officer Lewis refers back to this slide, the second slide will be a picture of non-conformance on the day that y'all set for non-conformance.
Okay.
So this is, again, case number 19-05. The board previously found that found violations to exist on this property and ordered the defendant to correct by February 5th, 2019, and to pay the costs of $115.66. And the property is not in compliance, as the property did not apply for or make any attempt to obtain a permit for the shed that's on the structure. So, Officer Lewis, have you re-inspected the premises at 2314 South Hopkins Avenue to determine whether the owner has brought the property into compliance?
Yes, I have.
And is the property still in violation?
Property is still in violation.
What violations still exist on this property?
Section 6-56, the City of Titusville Code of Ordinances, work without a permit, or permit required. Permit required accessory structure, correction. And
We have a 2-slide presentation. This is the second slide showing you a photograph of the shed in the backyard of the property.
Garage.
okay, and the larger shed is the one in question.
If a shed is under 120 square feet, it is exempt from the requirement to obtain a building permit. This shed is larger than 120 square feet.
Just like a garage.
It basically is.
Fair size structure, yes.
Are there any questions of staff?
Mr. Lewis, nobody in the office has said anything that they're gonna get this, that the boss man knows, or get out of my face or whatever?
Before, or after the last hearing, was it after, correction, was it after the last code board? No, after the initial presentation to the board last month, an attorney for Salazar Roofing called our office and said they would be obtaining a permit. To date, there's been no application nor a permit issued. And we've heard no more from the attorney, nor from the company.
And I've had no contact to my office regarding this case.
Really?
They should have taken their attorney's advice.
All right, what do y'all want to do?
Ed?
I'll make a motion.
Thank you, Frank.
I move to find that the board previously found the respondent in violation of codes and ordered the respondent to come into compliance by February the 5th, 2019, or a fine in the amount of $50 per day may be imposed.
February 4th.
February 4th, 2019. Respondent was provided proper notice of the prior order and proper notice of this compliance hearing. Respondent did not attend this hearing. Testimony and evidence show that the respondent failed to bring all violations into compliance by the compliance date. The daily fine shall be imposed beginning the day after the compliance date and shall continue to accrue until the property is brought into compliance as confirmed by the code enforcement officer. The city's total costs of prosecution are imposed in the amount of $115.66. The board's prior order is incorporated herein. The city may record this order, which shall constitute a lien on the subject property and other property owned by respondent.
Second.
Motion by Ashley, second by Mr. Richardson. Any questions? Comments? Roll call vote, please.
Member Edens?
Yes.
Member Herman?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Edwards?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Motion carried. So, to make things clear, they will be notified that they will be charged $50 per day for each violation, one violation, commencing back to February 5th, 2019. Okay. Attorney or no attorney?
Yes, ma'am.
Go ahead.
All right, thank you. The next case on the agenda is case number 19-07 for the property located at 1303 Vista Terrace. And Officer Tuggle is here to provide testimony as well as the PowerPoint presentation for this non-compliance hearing for this matter. The board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before February 4th, 2019, and to pay the cost of $133.27. The property is not in compliance as the violation still exists. Officer Tuggle, have you re-inspected the premises to determine whether the owner has brought the property into compliance?
Yes.
And is the property still in violation?
Yes, it is.
What violation still exists on this property?
13-26 overgrowth. This picture was the date of compliance.
This is the backyard of this one, if I remember
Correct.
correctly. Okay.
Does the board have any questions of staff?
And no one's living there?
I don't know. There's a car in the driveway, so I'm not sure if anyone's there or not.
When's the last time you were there?
This morning.
Okay. Any other questions y'all have? Oh,
Is that a white fence also, or some sort of, is that part of the same property?
It's part of the same property. There is a second white fence on the inside of the property line.
It looks fairly new.
It's been there for as long as I've been patrolling that area, so about
does it
3
belong?
years.
But does it belong to the backyard neighbor? 'Cause
No, it's on that property.
It's on that property, oh, okay.
One fence don't look that good.
And the grass looks mowed in the background, right? The grass is mowed, it's just this stuff up by the fence line?
No, it's the entire backyard looks like that.
Oh, okay.
The grass that's mowed is probably another lot,
This is
isn't
the
it?
next door neighbor's
Yeah.
lot. But somebody's mowing the front yard, correct?
They have been. When I went by this morning, it looks like it's been quite a while, so it's starting to grow up as well.
Yeah, because we had some rain. Okay. All right. Any other questions? Who wants to make a motion?
I can do it.
Go for it.
I move that the board previously found the respondent in violation of codes and ordered the respondent to come into compliance by February 4th, 2019, or a fine in the amount of $50 per day may be imposed. Respondent was provided proper notice of the prior order and proper notice of this compliance hearing. Respondent did not attend this hearing. The testimony and evidence show that the respondent failed to bring all violations into compliance by the compliance date. The daily fine shall be imposed beginning the day after the compliance date and shall continue to accrue until the property is brought into compliance as confirmed by the code enforcement officer. The city's total costs of prosecution are imposed in the amount of $133.27. The board's prior order is incorporated herein. The city may record this order, which shall constitute a lien on the subject property and any other property owned by the respondent.
Second.
Motion by Ashley, second by Ed. Any questions? Roll call vote, please.
Member Herman?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Edwards?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried.
15 minutes, 16
That's
minutes,
it.
and we're through.
Don't tell anybody.
I should play it on.
All right, we go to Board's Attorney's Report, which is our turn to go to school.
Can I show this?
Well, Madam Chair, you asked for a discussion about fines and also to discuss the motions. On the fines, just for, to refresh your memory on what the fines are for code enforcement, in Chapter 162, you can,
That book,
Chapter 162 is the Florida statutes. Under Florida statutes, you are able to fine not more than $250. No, that's the IPMC.
Okay.
I don't know that you have the Florida
no, we
statutes
don't.
in
That's
front of
okay.
you. You can assess a fine of up to $250 per day for a first violation. If you have a repeat violation, you can assess a fine up to $500 per day.
For a repeat?
For a repeat violation. So up to $250 per day for the first violation. The first time, that means the first time you're seeing the case, the first time code staff brings the case before you. You can go up to $250 per day and up to $500 per day for a repeat violation. Pardon?
Oh, go ahead, I'm sorry.
I just want to chime in that the city has often found, not in the past couple of months, but oftentimes we will bring in cases that have multiple code violations against a given property, and you can fine the property up to $250 per violation, and that may be something that you want to get into, is distinguishing between different violations against a single property when there's upwards of 3, 4, or 5 different violations. I've had cases that have 7 or 8 against one property, so that could multiply the total fine against the property up to over $1,500 a day if you wanted to go there. Sorry for interrupting.
Yeah. Now, yes, that's correct. You can assess a fine per violation, and I have seen you do that if you want to. That can really raise the fine. Under Florida statutes, you have criteria that you have to follow when you're assessing a fine, and you need to be sure you keep this criteria in mind when you are considering how much of a fine you want to impose. The first is the gravity of the violation, which makes sense. If it's a very serious violation, you would impose a higher fine. If it's a very minor type of violation, then maybe not so high of a fine. The second criteria is any actions taken by the violator to correct the violation. That's where you would want to ask code staff, or code staff would want to bring forth information that, yes, the person has been working with them, or no, the person never calls them back, they don't make any attempts to correct. If they make no attempts to correct, if they're ignoring code staff, then you might consider a higher fine. If they're very compliant and they're working very hard to get their property fixed, they're just, it's a financial hardship, or they're just, they work a lot of hours and they just can't get to their property, then you might want to consider a lower fine. And the third criteria that you must consider when you're assessing a fine is any previous violations. And you probably wouldn't know that unless code staff brings that to your attention, that yes, this is a problem property, or no, this is the first time we've ever had to deal with this property owner.
At any point, like today, the ones that have not come in compliance, and they're at $50 a day per the violation, at any time, do we have the opportunity to go back and refine them again?
No.
Maybe to get there, no?
You,
Okay.
Normally, no. Once you set your fine in your first order, that's the daily fine. And that's what you're assessing. And if they don't come into compliance, then that fine will run until compliance.
So it could rack it up a bunch.
Could rack it up for however many days or years that they are in non-compliance.
Okay.
The fine that you stated for repeated violations, has it always been up to $500 a day?
Yes, sir, yes.
The reason why I ask is because it's the first I've heard of it.
Yes, you are authorized to go up to $500 per day for a
Per-
repeat violation.
Per violation?
Per violation, yes,
Ouch.
yes.
Yeah.
So now that your PowerPoint presentations actually ask for a certain amount, I mean, I realize that in the ultimate, it's whatever motion we make, but you guys are doing your research as well, right? That you're asking for something that seems reasonable, you're letting us know when it's a repeat violation, and if you think it's that egregious, you'll ask us in the PowerPoint for the $150, the $250. We
Yes,
can pretty
ma'am.
much kind of,
Basically, as we started out, most of the ones you've seen, we've come in reasonably into what the board normally has done in the past. Based on the board's attorney at that last meeting, is now when you get that number, it'll be provided, the officers will provide where that number came from. Now, it may be the very same that it was, but if it's more, they'll provide that testimony as to why they've suggested that amount. And again, those are just suggestions by staff. The board
but it's
has
helpful. It's a guidepost, and it
And-
kind of lets us see where you feel like how egregious it is, and you know, how many repeat violations you've had before, but it's a
Right.
great guidepost for us.
Yes, ma'am. So, does that answer your question?
And that's great, because not all code staff does that, and that's the perk of getting a recommendation from code is the assurance that they've looked at that criteria, and they've got the knowledge of whether there's been previous violations. They can testify that this is a very serious violation or a not so serious violation, and they're the ones who can tell you if they've been able to work with this particular person. Now, I will let you know that there is another third fine option. I don't know if I've rarely seen this third option, but there's an option to assess a fine of a flat fee of $5,000, just a flat fee, not a daily fine, if it is a irreparable or irreversible fine. And those are pretty hard to find, but they are typically violations that just cannot be cured. So you don't give them any time to comply because there's no opportunity to comply. There's no way to fix what they've done. And again, that doesn't get presented, in my experience, not very often, because it needs to be something pretty egregious and something that you just can't, there's nothing in the code that can fix it, and there's nothing in reality that could fix that violation.
And how does that ultimately end up in the grand scheme of things? Because no one finds it in compliance, right?
It can't be found in compliance. It's just a $5,000 fine that gets assessed. And you would have one hearing on it, one finding on it, and it would get recorded as a lien.
Would there be a code number for that type of noncompliance? I mean,
Well, the actual code violation would be the number of whatever specific code is. Typically, where you would see that is like if you had a code that has specimen trees beyond 24 inches, and someone takes down one that's 32 inches, you can't put that tree back. And that's typically where those come in. Or if someone, I know of two cases, one of them was a tree of that caliber, and another one was a person rented a excavator to make a creek in their yard, and they fixed the city's creek. And it caused a lot of issues with St. John's. And that too was a flat fee.
The one point about the tree, that's typically the example that we use for an irreparable violation. However, a lot of times in city codes, there's mitigation allowances. So if somebody takes down a tree, some city codes, and I'm not aware of your city code, but some city codes will provide a mitigation relief to the city. In other words, that you would tell the person who cut down the tree, we're going to assess you an administrative fine, and you have to plant 10 trees to replace that one tree. So there is a cure available if there is a cure available within your city code, then it wouldn't be an irreparable violation. Any other questions about assessing fines?
Y'all all right with this information?
Glad we have a board attorney to remind us of all this, because there's no way I can remember that.
It gives us something to really consider.
Yeah, well, I guess it's opportunities to look at different things. Any other questions that y'all have about motions and fines and anything?
How do you like the motion formats? Obviously, it doesn't cover every situation. Like I didn't give you one for finding someone in compliance, because it's just, I find this case in compliance, so.
That was going to be my question. Other than that, it's fine.
I like them.
Although RL pointed out for this repeat violation form, I probably could have, for the two that we found in compliance, read through the first section and then went to 7A in compliance now. I mean, it was a lot of words for the same effect, but if I had to.
That's for a repeat, yeah. The third one is a repeat.
Oh, I
Yeah.
see. Okay. Not repeat in that second hearing, repeat in that they've been here before.
Because they've been here for a first hearing, and now they're here for the compliance hearing, yes.
Got it.
So that's number 2 is for the compliance.
I think these motions are really easy to read and understand.
Good. Now, I didn't really talk much before about the serious threat abatement of a nuisance. I have included that in your motions number 1. And that's really the city's call if they want to ask you to find something as a serious threat. So under the Florida statutes, you'll have a violation, and if that violation constitutes a serious threat to the health, safety, and welfare of the citizens or the person who resides there, such as it's a mosquito breeding area, or it's an open pool where there's children in the neighborhood and that it's not secured, those kinds of things can be considered serious threats. And if the city wants to fix it themselves, then they can ask the board to make a finding, an actual separate finding, that this violation constitutes a serious threat. And it authorizes the city to go out and fix it, and then they would assess the cost of that repair to the owner.
Would the city bring this to our attention, or do we bring it to the board's attention?
Both. You can, if based on the testimony that you're getting from the code officer, you can ask the officer, do you find this to be a serious threat, and do you want us to authorize the city to fix?
The reason why I asked, because I remember in the past we've had cases where there was a abandoned property or something in the open pool, waters turned absolutely green, or whatever color that was. Yeah, which is breeds mosquitoes.
Right.
Would that?
Yes, that certainly could, but just because you authorize the city to fix it doesn't mean that the city has to fix it. It's just giving the city the opportunity and the authority to fix it, go out there and clean up the pool, or go out there and secure the pool if they have the funds and resources available to do so.
Which is something I still can't understand. If the city brings their property into compliance, then the property is no longer in violation. That doesn't make any sense to me. I mean,
But they can assess the cost.
They can assess the cost.
Well, I haven't, we had a case not too long ago where I don't believe that was the case. You guys went out and corrected the property, and the property was no longer in violation, and it seemed
It
like
was
the
no longer in violation,
owner.
but we'd still assess the actions taken.
Did you go back and do some more cost recovery? Okay, well.
We always file that. That's
Well,
an
I know
action
you
out.
have the initial cost recovery, but did you do
Right,
another?
anything that we do that's outside this board is handled through the legal department.
Subsequent cost recovery for subsequent actions does follow a process different from what you see here. After a finding of a serious threat and an order for nuisance abatement is presented to this board, my analysis is that it provides the code enforcement manager, Tellison, the authority to present a case to the city manager for the resolution of necessity, which is additional hearings before the city council where all interested parties are noticed. And then the lien is recorded after certain actions are taken according to the city's code. So this is the precursor to those steps.
Very good. Okay.
Let's take a case that was about a year and a half ago, maybe that, where a property was abandoned. It's an awful repair. And the son did not, there was no title on it. The son didn't want it. You remember that?
Yeah.
And it's still sitting in that location. And it is kind of a nuisance.
I believe it's running a daily fine against the property, and
Yeah, but if nobody claims it or do anything about it, that's when I think you should ask the city manager to tear it down or something.
Actually, there's some actions going on in reference to the demolition of some properties that are coming soon in front of council.
That's good.
We met on that last week, and where we're going forward on some of those. As with, you'll see some cases starting to come through that are going to ask for demolition from y'all.
So that's in a case where this section 11 of,
Serious threat and abate.
yeah, comes in compliance or
Yes, sir.
is used. Okay.
because the city's preference is to have the owner or a party that's interested with the property to be the one that apply for and proceed with the demolition or securing of the property, there is a long process involved and there's costs associated that the city has to recover. And because of that, we go through the resolution of necessity process in order to get there. And then we end up with an additional lien that's usually several $1,000s against the property that's valued at much less than it was at the beginning of the case. And so it's not something we rush through, but we do like to take care of these properties in that manner.
And on top of all of that too, we still have vacant registry here. Some of those with the pools, I reach out to them independent of the board and hold them accountable and make them go do the work. Be it just board up the pool or get with Brevard County out mosquito control and those kind of things. So there are a lot of actions that go outside the board. But if we did and we brought it forward with the charges, of course, it would be part of our testimony and ask for that.
Yeah, and of course, we can ask the question whether it's a serious threat or not.
Yes, sir.
also.
Absolutely.
If I could just comment one thing on the fine discussion that we had earlier. I heard a couple of you mention that repeat violations, fines were unfamiliar to you, and they have been in the statute for some time, but there are certain criteria that are required in order for the city to present a case of a repeat violation. It has to be the same owner, the same exact code violation, and it has to have been within the past 5 years. So we have to see all of those three things met before we can tell you, okay, this is criteria met for a repeat violation. It doesn't happen that often, fortunately, but those extra tools are available to you.
And with what Ms. Farrell just said, if you recall, we have done one repeat violation here within the last year, and the officers put it in that testimony and on the PowerPoints. This is a repeat case.
Walmart was a repeat.
I don't recall that.
It was a single-family residence with overgrowth.
Okay.
And anyway, y'all would be the first
I thought Walmart was a repeat from the
That was year before,
storage.
17. Okay.
Actually, she's correct. We did bring them as a repeat, but it got resolved.
On the same subject, maybe I shouldn't even bring this up, but maybe I shouldn't.
All right.
Maybe I shouldn't. Forget it. 'Cause, well, yeah,
Or is it something, we'll be happy to answer it, sir.
Royal Oaks,
I'll
The
still
golf
the
course?
same. No one says, did it take somebody to complain about it, to bring it before you guys again? Because I go by
talking-
there almost every day.
You're talking about a property that's in foreclosure, and I think that any code enforcement action would slow down the foreclosure and it would end up in a valueless judgment. So
Okay,
I don't know that that would be a case I'd recommend going forward with.
all right. I'm just curious, because I'll shut up.
No, but that is a good point, is unfortunately, the city's code liens do not take priority over mortgages. And despite cities making valiant efforts to gain priority over mortgages, they just simply don't. And if there's a pending mortgage foreclosure action, then it's almost useless to put forth the efforts to bring a code case when there's a pending mortgage. And what you hope for is that a new buyer comes in and takes over the property and cleans it up.
Anything else?
Well, one thing on that point, I would assume that the new buyer comes in and he has to negotiate with you on the fines.
Yes, sir.
Okay, but if he commits to cleaning it up within a certain time, you're flexible on the fines.
That's correct.
Okay.
Yeah,
If
yes.
there's a running judgment, it depends on what's going on with the property. It depends on the nature of the property. If a mortgage foreclosure is going against a property that does have a recorded code enforcement judgment, we are wiped out in the foreclosure action at the end of the day. There's not much negotiation I can do for any running fines. My office charges $100 to record a release of the lien when the final judgment operates to release the city. So we only collect $100, and it's not even close to the cost recovery of bringing that case. And so that's just the way Florida law operates these days. If it was a tax deed sale, it's a different scenario than the city's lien does survive. So it depends on the nature of the case. It has to be a mortgage foreclosure to fall into that set of circumstances. But of course, mortgage foreclosures are frequent against properties that are abandoned.
Anything else? Do you have anything else, Deborah?
Nothing more.
Okay. Chelsea City Attorney's Report.
I have nothing, thank you.
Mr. Tolson, Code Enforcement Manager's Report.
Are y'all in favor of the non-compliance PowerPoint, or?
Looks
I like
good
your
to me.
PowerPoint. I like your PowerPoints.
Again, we're trying to continue to better what we do for y'all, so.
Definitely more streamlined.
Yeah, and I'm thinking if we can show you, it reminds you of what, because sometimes it may not be the next hearing, it could be 2 or 3, and we want to give you exactly what transpired at that last meeting.
I do have one question for you,
Yes, sir?
and I don't know if I can ask it or not. But when Officer Crisco retired,
Yes, sir.
do you still have the same remaining staff?
Minus him.
Okay, okay.
Yes, sir.
I just wondered.
Joe looking for a job?
Yes.
No.
He wants that truck.
I noticed he's wearing the blue shirt, so I'm not sure where he was going with that.
I've got a track.
Yeah, see, you got on the blue shirt.
Joining the team.
No, no, no.
All right. Anything else? No. Okay. Chairman's Report. I don't have anything. Do y'all have anything when you bring up? Board members' report? Then I guess we are adjourned.